Welcome to the Republican Professor Podcast. I'm your host, Dr. Lucas J. Mather. It's December 30th, 2024. I have less than 2 days to do something I wanted to do all year. Actually, I wanted to do it back in 2022. I didn't do it in 23 either. Chevron deference. It's one of the most difficult things to talk about, I think, on the Republican Professor podcast. That's why I've been avoiding it. But the Supreme Court reversed Chevron deference this past year. And so I made a commitment to myself that sometime in 2024, we're going to talk about Chevron deference in some detail. We're going to start talking about Chevron deference in some detail. And we're going to do it the right way. We're not going to do it the Wikipedia way, which is it's fine. You can look up Chevron deference on Wikipedia or whatever. There's lots of different summaries of the concept Chevron deference, the doctrine as it developed, as it was initiated. Um, and that's fine. Do that. But that's not really what I want to do on the Republican Professor podcast. Why would I do that when you can look that up somewhere else? I want to do a deep dive on Chevron deference. And I want us to think about the moral foundations that, sorry, I had to get a drink of water. The moral foundations that undergird our constitutional system, our national ethnicity as Americans. And sometimes it takes somebody dying. And I'm not talking about Jimmy Carter, okay? He just died yesterday. Sometimes it takes somebody dying where you look at their life in an obituary and it reminds you of why we're doing what we're doing. And I'm thinking of David Boris Rifkin Jr. Thanks to Dr. David Horner, a TRP podcast guest in 2022, one of my former professors, for sending me this from the Wall Street Journal. I'm just going to read. The immigrant from Soviet Russia became a leading champion of the U.S. Constitution. Why do you think he became a leading champion of the U.S. Constitution? Well, because he grew up in a place that had nothing like that. The Soviet Union has a Bill of Rights. Did you know that? They don't have separation of powers. Separation of powers protects individual liberty. That's the natural law angle. That's the moral arc of the Declaration of Independence, coming to institute institutions which protect through the structure the conditions necessary but not sufficient for human flourishing. The Soviet Union was it was so rough on people because necessary conditions for human flourishing were missing. And that's what this guy, David Boris Rifkin, got 1956 to 2024. This is from the editorial board, December 27th, 2024. Rifkin's life, I'm reading from it now. Rifkin's life is a great American story. He was born in the city of Pskov in what was then the Soviet Union. He made his way to America alone as a 19-year-old in 1976 amid the wave of Jewish immigration. He later converted to Catholicism. Rifkin worked multiple jobs, including busboy and gas station attendant, and he talked his way into Georgetown by asking the dean if he could attend classes. He earned a bachelor's degree and a master's in Soviet affairs and went on to Columbia Law School. He quickly made a name for himself in the legal world and in 1980s became an associate in the White House counsel's office and in the Justice Department policy shop as legal counsel and advisor to Vice President Dan Quayle. Only in America, as they say, could someone survive as an immigrant without a dime and a decade or so later work in the White House. Conservatives who want to ban all immigration might reflect that they would have lost the contributions of a man who became a leading conservative legal mind. Even as he represented clients as a partner in Baker Hostetler, Rifkin played an active role in America's policy and intellectual debates. This is a short piece. It's just got a few more paragraphs. He took pride in winning an essay contest at the Naval Trade Magazine in 1984, defending the Reagan maritime strategy. He made himself an expert on nuclear deterrence strategy, and one or more memorable experiences with listening to David and Henry Kissinger discuss Russian foreign policy over lunch. Notice these are all Republican names. Rifkin's special passion was for the Constitution and what he calls its elegant structure for protecting individual liberty. He saw the separation of powers as the bulwark of that protection. Amen, brother. Both the vertical separation between the states and the federal government and the horizontal separation among the three branches of U.S. government. Mind if I read that again? I'm going to read that again. I want you to pay attention to what this is saying. Rifkin's special passion was for the Constitution and what he called its elegant structure for protecting individual liberty. He saw the separation of powers as the bulwark of that protection, both the vertical separation between the states and the federal government. And Democrats are loving that right now. They're loving that right now as we get ready to inaugurate Trump. And the horizontal separation among the three branches of U.S. government. That's what Chevron deference is all about. And we are getting there. We're going to get there. These checks and balances, I'm sighing here because separation of powers is not the same thing as checks and balances. So I'm going to have to talk to these members of the editorial board. Checks and balances are different than separation of powers. Related, but they're not identical. It's kind of like in a triangle, you have triangularity and trilaterality, but they're not the same thing. They're coextensive in this. They are instantiated at the same time, but they're not the same thing. These checks and balances are as crucial as the Bill of Rights to the defense against dictatorship. I have another thing to say about that sentence. I'm going to say the whole sentence. These checks and balances, I'm wincing here, are as crucial as the Bill of Rights to the defense against dictatorship. No, I would say they're far more important. Separation of powers is far more important than the Bill of Rights. No, they're not as important. They're far more important. The Soviet Union had a Bill of Rights. It was mere parchment. It was meaningless. Without checks and balances, um, which occur alongside of or with, together with separation of powers, you know, the Bill of Rights means nothing. It's mere parchment. They're parchment barriers. This conviction led Rifkin to take the intellectual lead in challenging Obamacare's individual insurance mandate. As you know, that mandate was upheld by Republican on the Supreme Court. Remember that? But that was not entirely a loss because of the reasoning. The reasoning was good insofar as the Republicans were correct on the Commerce Clause. The Supreme Court embraced his arguments on the limits of the Commerce Clause. See, yeah, that's really important in maintaining that vertical separation between the states and the federal government. Because the Commerce Clause, I mean, the Democrats, they want to take the Commerce Clause and they want to erase any kind of separation of powers between what he's calling vertical separation between states and federal. They do it through the Commerce Clause. Democrats do. The Supreme Court embraced his arguments on the limits of the Commerce Clause, even as it upheld the law on other grounds. Rifkin advised many state attorneys general on how to challenge federal intrusions on enumerated state power. He played a leading role in overturning the Obama Clean Power Plan, among other abuses. Rifkin didn't mind controversy, and he was a rare member of the Washington legal establishment willing to deplore the use of lawfare against Donald Trump. Good for him. His argument in these pages explaining why presidents have some constitutional immunity from criminal prosecution was ignored at the time by the conformist legal press, but again, he was vindicated by the Supreme Court. A search of our database found no fewer than 243 David B. Rifkin Jr. bylines in these pages. That's the Wall Street Journal. Over the years, often with a co-author, and the first appearing in 1988 on the Byrd Amendment to the INF Missile Treaty. Excerpt from his writings appear nearby. Even as he was burdened by illness in his final weeks, David was on the phone urging us to weigh in editorially on this or that subject of the current day. He was a great friend of ours and of America's vital role in the world, and his wisdom will be missed. That's the end of it. That's a per curiam obituary from the editorial board, December 27th, 2024, 5:04 p.m. Eastern Time, from the Wall Street Journal. Thanks for the Wall Street Journal for making this material available to us, especially the editorial board. My understanding is that there is some disagreement that often occurs between the editorial board and the staff reporting at the Wall Street Journal, although I confess I'm not entirely up to speed on all of that. But now that just shows you that foreigners who come to the United States see sometimes what we have, and it's almost like they're ethnically American before they even get here. And they get here and they get it. They get the ethnic identity of American constitutionalism. And I don't mean ethnicity, American ethnicity in terms of race or what you look like, color. It's like being Jewish in the sense that it's a condition of your soul, what the Old Testament calls circumcision of the heart. And um, if you're not biblically literate, you're going to not get that reference. But what I mean is our circumcision of the heart in terms of American ethnicity is that you're an American inwardly, if you understand American constitutionalism, which he clearly did. He clearly did. And my guess is it was prefaced by great suffering in the Soviet Union. So you have a radical left-wing regime that does not have separation of powers. Well, it led to a real appreciation of the fact that separation of powers, if it's real separation of powers, together with checks and balances, and the Bill of Rights doesn't hurt, certainly doesn't hurt, uh, can really help protect the necessary conditions for human flourishing. Now, in that vein, I want to broach the Chevron doctrine, Chevron deference. And the way I'm going to go about that is by going back to 1982, the primary sources. Okay. Natural Resource Defense Council, Inc. versus Anne M. Gorsuch, Administrator, U.S. Environmental Protection Agency. Here it is. The D.C. Circuit Court of Appeals argued May 21st, 1982, decided August 17th, 1982. I was in second grade, so I don't remember this personally when it happened. But Anne Gorsuch was the administrator of the U.S. Environmental Protection Agency, EPA. And she was on the same side as General Motors and, uh, well, Chevron, um, the American Petroleum Institute, Chemical Manufacturers Association, Alabama Power Company, etc. Um, she was appointed, she had been a Republican congressman in the 80s, representing somewhere in Colorado. I can't remember. Was it Boulder? Was that before Pat Schroeder? Pat Schroeder was representing Boulder for the longest time, so I don't think it was there. Where was she? Maybe it was close to Boulder. I don't know exactly which district it was, but Anne Gorsuch was appointed by President Reagan to run the EPA, and she lost this case at the D.C. Circuit Court of Appeals in 1982. And that means that Ronald Reagan lost because this is Ronald Reagan's administration. She's in the Reagan administration, 1980. President-elect Reagan won against Jimmy Carter, who died yesterday. Anne Gorsuch had a son named Neil. Neil ended up going to school in New York City, Columbia, and then I believe he went to Harvard for law school. He went to Oxford for a DPhil in legal philosophy, studying under John Finnis, and now serves on the U.S. Supreme Court after 10 years on the 10th Circuit Court of Appeals in Colorado. And now this is interesting. Anne Gorsuch lost at the circuit court, but won at the Supreme Court a year later. Um, Neil was on I got to look this up here. Hold on. Okay. John Roberts wrote the opinion over reversing Chevron just this past year in a decision called Loper Bright. And Thomas, Alito, Gorsuch, Kavanaugh, and Barrett joined. So it was all Republicans on one side. Thomas and Gorsuch filed concurring opinions. Okay. Kagan filed a dissenting opinion in which Sotomayor joined and which Jackson J joined as it applied to this and that. Jackson didn't take any part in part of it. So you got the Democrats on one side and you got the Republicans on the other. Um, so the Democrats are defending Chevron deference this past year in Loper Bright. And you've got Republicans all stacked on the other side against it. Okay. Well, I'm going back to 1982, and I'm going back to an opinion for the court filed by Circuit Judge Ginsburg. Now let's disambiguate it. I'll just remind you there were two Ginsburgs on the DC Circuit in the 80s. One was a guy named Doug Ginsburg, who was appointed in 1986 by President Reagan. But this is 1982, so this is before Doug Ginsburg. This is the other Ginsburg, Ruth Bader Ginsburg, who later was appointed to the U.S. Supreme Court by Clinton. And she was appointed to the D.C. Circuit Court of Appeals in 1980 by President Jimmy Carter, who just died yesterday. So this is a Democrat who is against Chevron deference because there was no such thing as Chevron deference per se here because this is the case before it reached the Supreme Court. And then you have the Chevron deference decision in 1983 overturning this case in 1982, which Ginsburg did this decision for the three-judge panel that Ginsburg writes. And Ginsburg is on the panel with Mikva, who was appointed by Jimmy Carter, succeeded by Merrick Garland. Perhaps you've heard of him. And another guy named William J. Jameson, who was a senior district judge in Montana. And that guy was really old. I mean, he was appointed by Eisenhower. So he was a Republican on the panel. But you only need two of these guys for the whole thing to go. And this guy is really old. And so you have some disagreement among Republicans here. You have an Eisenhower guy on this original panel. And then in this panel decision, when it gets overturned at the Supreme Court in Chevron USA versus Natural Resources Defense Council, Inc., et al., that was argued February 29th, 1984, decided June 25th, 1984. Sorry, 1984. I said 1983 earlier. Justice Stevens delivered the opinion of the court in this Chevron case. Okay. I don't see any dissenting. Let me just double check to see if there were any dissenting opinions. Hold on a sec. Okay, I thought so. I just had to double check. Justice Stevens wrote the opinion of the court for the Chevron case, the Chevron decision, but it was unanimous. And who was in on this panel at the Supreme Court? Well, one Democrat and two Republicans took no part in the consideration of the case, but otherwise it was Stevens, Berger, Brennan, White, Blackman, and Powell. So you have a bipartisan majority on the Supreme Court, and you have Stevens, who's like, man, I don't really like Stevens, to be honest with him. I know he's a Republican, technically. I don't like him. But, and then you have Blackman, who's a Republican, but he wrote Roe versus Wade, and you have White, who dissented on Roe versus Wade, who was a Democrat, appointed by JFK, the only JFK appointment there. Um, and now, this past year, that's 1984. Well, 40 years later, you have Loper Bright, and it's overruled by Republicans only, defended by Democrats only. So what's going on here? Kramer is saying to Seinfeld, Jerry is saying to Kramer, what's going on here? And Kramer says, what is Kramer saying here? So that's what we're going to get into. We're going to do a deep dive on this. Now, if you're bored, that might be a sign. That might be a pretty good sign because this is very important stuff. I really have some trepidation here because this is important stuff and I don't want to screw it up. But I also don't want to go through this so quickly that it's of virtually no value to you in terms of a lasting understanding of the deeper things involved here. So let's just get to it. I'm going to read and comment upon Ruth Bader Ginsburg's decision, which, remember, will sound something like Loper Bright this past year, only Republicans. So that's why it gets a little confusing here. What's going on here? This case involves a dispute, Ruth says on page 320. How do you find this? This is a 685, the second series of the Federal Reporter, page 718, 1982. And I'm going to just demonstrate how you find it on Google Scholar so you can follow along, because this is an educational podcast and I want you to follow along. Okay? Okay. Guys, come on now. Let's go to Google Scholar. Okay. Let's go to case law, federal courts. Okay. And we have Natural Resource Defense Council. They're a very common plaintiff versus Gorsuch. Okay, there we go. See, it's 685, the second series of the Federal Reporter, starting at 718. And so that's how you would cite it in your paper, right there in your footnote. Along the side there, see 719? That would be the page number in the volume, which is in the library of any good law library. And you could go check it for yourself. And I have checked this, and it is the same. Google's not playing any games with you. Why is it at 718? Well, it starts at 718. All this front matter is on 718. At 719, you're going to see this guy David, the name David there, and all this other stuff. And then you're going to see 720. You see how it's in the middle there? That's page 720. So if you were to go to the law library and open up this volume, 685th volume, in the second series, 1982, page 718, at 719, bubble concept would be the last word on 719. You turn the page to 720 to a discrete Clean Air Act or Act scheme. That would be the following page. So if you're quoting from this or you're summarizing it, you should cite that where you're getting this information. And if you were citing bubble concept, the first time that word occurs and it refers to the Clean Air Act, you hit that footnote, you put 685 F dot 2D, which means the second series of the Federal Reporter, space 718, okay, and then you put a space, parentheses, 1982, okay, and then you'd have a comma. No, sorry. You could just put another space at 719 through 720. So anyway, learning how to cite this is very important. You want to give credit for where credit is due. So let's just go through this. Okay. This case involves a dispute between the Environmental Protection Agency, supported by industry interveners, among whom was Chevron, who appealed this decision and then got this overturned at the Supreme Court 2 years later. And petitioning environmental associations concerning EPA's application of a bubble concept to a discrete Clean Air Act scheme, the new source review requirements for areas in which air quality does not meet federal standards. In other words, non-attainment areas. The controversy centers on the appropriate definition of the word source for the purpose of implementing the statutory scheme under EPA's current bubble concept regulation, effective October 14th, 1981. Source means an entire plant. Let's stop right there. Let's remind ourselves of what's happening here. This is a District of Columbia appeals court. What's in the District of Columbia? Federal agencies. So if you're appealing an action by a federal agency, you can go right to the appellate court, appellate review, and goes before a 3-judge panel ordinarily. And at issue here is the 14 October 1981 rule, right? That rule. Whoa, what happened? Oh man, what did I just do? Oh, brother. Let me figure out what I just did. Sorry. I'm back. I was trying to make it bigger. Who was president on October 14th, 1981? That's right, a Republican, Ronald Reagan. Remember that. Who was president before him? Jimmy Carter, a Democrat. You have a distinction between Democrats and Republicans. Now, you have Anne Gorsuch of the EPA, who's in her job is to ostensibly is to protect the environment, right? Well, notice who's on her side. According to Democrats, these would all be polluters. These would all be the companies and parties that are enemies of, quote, the environment. And so Gorsuch should not be on the same side as these industries and these companies that are polluters. But she is. And so, according to Democrats, it would not be surprising if you said Anne Gorsuch is a Republican. And they'd be like, well, of course she's a Republican. Republicans are on the side of pollution and hurting the environment. So you have a party like this Natural Resource Defense Council, which is a public interest law firm, which goes around suing on behalf of the public whenever they see government agencies doing stuff that they don't like. For example, teaming up with Rubber Manufacturers Association, Inc. or Chevron, which they don't like because they make gas, they make gasoline, and they make petroleum products. They hate these distinctions are still there, and they were there in 1980. They were there in 1979. Okay. So you have Ginsburg, Ruth Bader, famous Democrat, right? Who is writing this as one of her signature pieces before she got on the Supreme Court. And in fact, it's, probably one of the things that got her on the Supreme Court, this thing right here. So what's at issue in these regulations, these EPA regulations promulgated by Republicans under Reagan, was how to interpret a word in a statute. A statute passed by Congress, signed by the president, which has a ostensible purpose of making the air clean, creating standards for industry that improve air quality for people, for, quote, the environment. Not just people, but animals. So the controversy centers on the appropriate definition of the word source. And according to Republicans, source means an entire plant, not a plant like a biological organism plant, but a plant meaning like one of these industries creating a product to sell, a petroleum product. Well, why would the Republicans want source to mean an entire plant? Because it makes the regulations easier to comply with. Okay. While in the competitive business environment that these industries and these companies are operating in, they can make a profit easier under this Republican definition. Okay. So that's what this is about. And Ginsburg is going to say, no, no, you need a different definition, and the definition is going to make it harder to make a profit. And I don't care if it's harder for you to make a profit because we're cleaning the air, and that's important, and that's what Congress wanted us to do, and we're just doing what Congress wanted us to do. And uh, so she's going to take a position of judicial humility, judicial a posture of we're doing the best we can as judges to figure out what Congress has commanded us to do. You see the separation of powers angle here? And if companies and industries have a harder time making their products, so be it. We don't, that's Congress's problem. See, this ultimately goes down to the issue of the role of Congress, this whole thing. Now, let's get into this more. Under regulation previously in force, an individual piece of process equipment within the plant ranked as a source. Okay, let's take that. I'm going to do exactly like I would do in classroom. Because I mean, I'm sure that this is tough going for young people, especially some of your old people too. Um, under the regulation previously in force. Well, when was that? That was under Carter, the Democrat. So the Democrat interpreted this statute in a way that made it harder for companies to make a profit, not easier. Okay. Because of the definition of the word source. With the election of Ronald Reagan, that's not what she's saying, but I'm adding it to here so you see. Um, EPA changed its definition of source. See, with the incoming administration, between Democrat and Republican, there was a policy difference change toward oil and gas and toward the EPA's role in clamping down on their ability to make a profit and their ability to operate, essentially, just even exist. When I say make a profit, I mean to exist. Like if you don't make a profit, you can't exist. You got to make money. You have to make money. You got to pay your employees. You got to you got to put the lights on, you know, and you got to pay those pensions. EPA changed its definition of source. Okay. In ruling upon EPA's regulatory change, we do not write on a clean slate. Our course is marked by two prior decisions in which panels of this court, that is the DC Circuit, determined the applicability, vel non, of the bubble concept to distinct clean air programs. An Alabama Power Company, there's that one. The court held EPA must employ the concept in the Act's prevention of significant deterioration regime, PSD regime, a scheme designed to maintain air quality in clean air areas. In ASARCO Inc. versus EPA, 1978, the court ruled out application of the concept to national new source performance standards, NSPSs, which the Act directs EPA to set with a view to enhancing air quality. Okay. Let me point something out here. This language right here, we do not write on a clean slate. That is code for judicial humility. Judge Ginsburg at the time, later Justice Ginsburg, is taking the posture of saying, my hands are tied. This is not my opinion. Me, Ruth Bader Ginsburg. Okay. My hands are tied. Our course is marked by two prior decisions. In other words, we have stare decisis. It's horizontal stare decisis. You got two types of stare decisis, horizontal and vertical. Vertical comes down from the Supreme Court. You can't disagree with the Supreme Court. You're not supposed to. Why? Because Article 3 of the U.S. Constitution says there's one Supreme Court. And if you disagree with that, what you're saying in a sense is there's two Supreme Courts. There's the one over there, and then there's me. I just made myself the Supreme Court by disagreeing with the Supreme Court. That's called stare decisis vertical. Horizontal would be it's the same level, the same circuit, DC. And within this circuit, if we have precedent that speaks sufficiently analogous to the same situation, then that precedent will apply going forward. That's called horizontal stare decisis. So she's saying that the two prior decisions are analogous and they control here. And all she's doing is applying precedent, judicial precedent, to this issue of what the word source should mean, and hence the issue of how hard it is going to be for these industries and these companies to make a profit under the scheme that Congress has set out for them to operate under. And see the language of Congress, where's that in here? You see it? Well, she says the court held and the court ruled out, right? Here's the language of Congress. The act directs EPA. That's the language of Congress commanding the executive branch. Okay. And so she's saying, as a judge, I'm not in a position to question what Congress says. Congress makes the laws. Congress directs the executive branch, EPA, of what to do and how to, what regulations really fit. And of course, this is all regulating commerce. It's regulating private practice. And those are the parties before us here. But if the executive branch is not doing what Congress said to do, then the judges have to come in and say, hey, stop that. Do what Congress said. And so that's what she thinks she's doing is this is how she's presenting herself is not as a partisan, not as a Democrat on the DC circuit, but she's saying, my hands are tied. Congress has said this. Reagan wants to do his own thing over there. Gorsuch is doing whatever Reagan wants her to do. They're all Republicans. They're on the side of industry. They're on the side of oil and gas. But EPA is not supposed to be on the side of oil and gas. They're supposed to be against oil and gas here in this issue because that's what Congress said that EPA should be doing. All of that is in there. Okay. So let's keep going here. The separation of powers is all over the place here. Congress wants EPA to enhance air quality. where when it comes to national new source performance standards. So you see the word source in there? That's a very important word. What counts as a source? Is it at a new plant, or is it even a piece of equipment within the plant? Well, if it's the smaller definition, the piece of equipment within the plant, then there could be 12 new sources. Well, every time there's maintenance. And that's a lot more regulation than just the source regulations applying to the entire plant, one and done. Okay. So I'm going to continue. Congress, well, hold on a sec. Where did I go? In each case, I'm also reading this off this. I like reading from the piece of paper. So in each case, the court focused on the purpose Congress envisioned for the particular program at issue. I'm going to skip down a little bit. Congress, EPA does not dispute, intended the new source review requirements to operate not simply as a quality maintaining scheme, but specifically to promote the cleanup of non-attainment areas. We are therefore impelled by the force of our precedent. Notice this language here. She's saying, my hands are tied. It's not my opinion. It's our precedent. If I was a Republican, I would have the same obligation to just apply that precedent. That's what she's saying. To hold the EPA's regulatory change, meaning when the Republicans took control and gutted the regulation, its employment of the bubble concept to shrink to relatively small size mandatory new source review in non-attainment areas is impermissible. Now, she goes through the statutory framework. She talks about the origin of the Clean Air Act in 1970 and the amendments. This is under the Nixon administration. As you know, Nixon set up the EPA. Republicans set up the EPA. And the purpose was to protect and enhance the quality of the nation's air resources. So she's saying that the purpose of setting this all up was to improve quality of the air. That's going to be an important thing for you to remember. 1976, it was clear that many regions of the country had failed to attain these standards within a statutory deadline. There's all these deadlines. They're a little bit, it's a little bit much to keep up with all this stuff, but just so you know, there's standards and there's deadlines. Okay. And they try to be really serious about these deadlines, but at the same time, they don't seem to be very serious about them. Congress is trying to eat its cake and have it too, which is the purpose of having cake. They're setting up standards and they're setting up deadlines. And then they're saying, if you don't meet this deadline, well, then there's a new deadline. And you really got to meet that. But if you don't meet that, then you can meet this other deadline. And you have the requirement that states take a lead on here in this, and they're involved. They're coming up with plans that are called SIPs, SIP. And a SIP is, under this language, it would be a state implementation plan. So Congress established some amendments to the Clean Air Act, a comprehensive state and federal program to control existing and new sources of air pollution. Central to the new design, Congress charged EPA to prescribe National Ambient Air Quality Standards, NAAQS, NAQS, and required all states to adopt and submit to EPA for approval state implementation plans, SIPs, that provide for timely attainment of these national air quality standards. Well, they're not meeting the deadlines. And there's a Part D that passed that said that there are more deadlines for these SIPs. If you missed the attainment, um, you had to supply a plan for how you're going to not miss future deadlines. And the reason that, well, a Democrat way of understanding this might be to look at industry in the most the least favorable light. The Republicans are looking at industry and they're saying, this is kind of a lot you're burdening industry with. And you're basically making it a lot harder for these products that we need to be produced at a profit. And they have to be produced at a profit if they're going to be produced at all. Okay. And there's lots of people in the middle between these two. My guess is that this is a constant readjustment. At the heart of the present dispute are two features of Congress's 1977 alterations: the Part D permit program and the prohibition of major new construction in non-attainment areas lacking a SIP that meets the Part D requirements. In other words, when you see the words "at the heart of the present dispute," focus in on that. That's her saying, you want to pay attention. Fairly recent, 1977. It's only 5 years before this. There was a permit program for states that hadn't met the deadline. And the prohibition of major new construction in non-attainment areas. So those areas that were clean, according to the standards, had a freer reign. But if you were in this non-attainment area, meaning you're in a dirty area, air area, we're going to take a closer look and give you a harder time about more construction you want to do for your business or your industry. Okay. I mean, take a look at these four conditions. States may issue a permit for construction or modification. We're still in the statutory framework, which is background here. States may issue a permit for construction or modification of a major source of pollution. Okay, emission. If these four conditions are met, right? First, the increased emissions from the proposed source There's the word source again. So you can understand if you don't know what this word source means, then how do you plan for the future for your business? First, the increased emissions from the proposed source, which has not been defined, must not exceed the allowance for growth. Okay. Right now, I'm just trying to get you to see how important this word source is. Or alternatively, the applicant must obtain sufficient reductions in emissions in the non-attainment area to offset the increased emissions, blah, blah. Second, the proposed source must comply with the lowest achievement emission rate. Third, the applicant must demonstrate that all the other major sources in the state under its control are in compliance. Finally, no permit may be issued unless the state is carrying out the applicable implementation plan for the non-attainment areas in which the proposed source is to be located. Now, if you're reading this and you don't know what source means, it might be a little bit frustrating to you. So what the Reagan administration comes in and says is, Jimmy Carter and the Democrats got the word source wrong. We're going to clean that up and we're going to define it clearly with one definition, and it's going to be clearer. And Ginsburg is going to say that will conflict with the purpose that Congress had in setting this program up. The non-attainment area lacks an EPA-approved SIP that meets Part D's requirement. The construction moratorium becomes operative. In other words, business down. We're going to crush your business. And no major stationary source that would emit blah, blah, blah shall be constructed. In other words, you now have, we're cramping your style majorly. Let's get to the EPA regulations. Part D, as dense as it is, doesn't it make you feel better? If you were like thinking, gosh, this is really dense. Is it just me? No, she's saying, no, as dense as it is, does not explicitly define what Congress envisioned as a stationary source. Now, I want you to read that again. And, I'm going to take a sip of water while you read that again. I'm getting some sunlight, so I turned a fan on. I'm on page 723B, EPA's regulations. Part D, as dense as it is, does not explicitly define what Congress envisioned as a stationary source. Nor is the issue squarely addressed. I mean, I can't believe I'm reading this. Nor is the issue squarely addressed in the legislative history. I'm going to say something that sounds a little bit disrespectful here, maybe, but Ruth, I'm going to call her by her first name. Ruth, you're saying that Congress dropped the ball here by using a word that's really important and not defining it. Do I have that right? And the definition is not in the legislative history. And then we could also talk about whether the legislative history is sufficient for defining that term. By regulation, the EPA has twice attempted to provide a clear-cut answer. Now, here's where it gets really, this is the heart of this Chevron deference issue here. I want to slow way down so you can see how odd this is. By regulation, EPA has twice attempted to provide a clear-cut answer. Well, how in the world is EPA going to define a clear-cut answer to what Congress envisioned? EPA is not Congress. It's an executive branch agency. You see the separation of powers issue? She's talking as if EPA speaks for Congress. No, Congress. I feel like I need to stop sharing for a second. Congress speaks for Congress, right? Am I missing something here? How can EPA say what Congress meant if Congress never said what Congress meant? Well, she just takes it as, like, well, yeah, EPA is supposed to fill in the blanks. But EPA is a creature of politics. EPA is an executive branch agency, which last time I checked is in the executive branch. And who is in charge of the executive branch? Well, let's look up Article 2. Let's just look at Section 1. Here's the Congress, the Article 2, Section 1. Not Congress, but the president. The executive power shall be vested in a president of the United States of America. I don't see anything about Congress there in that first sentence. The executive power shall be vested in the Supreme Court. No, it doesn't say that. The executive power shall be vested in a Congress. No, it doesn't say that either. It says the executive power shall be vested in a president, a person, one person, he, singular. Very next word, he. EPA is under the president. The president is elected by the people. That's a political thing. The people elect a president to tell the EPA what to do. So why would it surprise the court here in the DC Circuit that when Reagan comes in and Congress has not defined this term source, that Reagan doesn't like the term as it was made up in the definition that Carter gave it. So he gives it a new one, more in keeping with how he's interpreting why the people elected him president. Let's go back to the text. By regulation, EPA has twice attempted to provide a clear-cut answer. The response it gave in 1980, that's under Democrat Carter. It was one way, rested on the notion that Congress intended a new source review to be an important tool in the drive toward attainment of ambient air quality standards. That's code for we want a strict definition of source, the one that gives the most teeth to the EPA in crushing the ability of these businesses and industry to make a profit and hence to even operate at all, to supply consumers with petroleum goods and services that they need and desire. Okay. EPA therefore designated its definition to subject to review more new construction projects in areas with unhealthy air than in areas where the legislative objective was simply to prevent significant deterioration of healthy air. Okay. On October 14th, 1981, that is when the Republicans took over under Ronald Reagan, EPA, upon reconsideration, dramatically altered its source definition. This time, the agency focused on, this is Anne Gorsuch, Neil's mother. This time, the agency focused on the regulatory burdens and complexities that the 1980 definition entailed, and on a state flexibility concern. So in other words, empowering states, if the state wants to be more friendly to petroleum industry, go for it. To reduce the reach of the permit and moratorium requirements, EPA conformed the non-attainment area definition of source to the definition applicable in clean areas. So in other words, you'd have the same definition of source whether in clean or non-attainment areas. Now, the 1980 regulations, this is code for Democrat. The 1981 regulations, this is code for Republican. She's not going to say that because she's a judge and that's not how judges talk, but I'm telling you that's what she's saying. The 1980 regulations make it harder for business to function. The 1981 make it easier. Of course, the Democrats are going to say, yeah, but another way to say it is the 1980 regulations make the air cleaner and the 1981 regulations make the air dirtier. Okay. Well, Republicans are going to say you have to think about the consumer and the economy. Those are all important things that you have to consider alongside of the environment, not instead of the environment, but alongside of the environment. And so you got to be careful that your environmental objectives are not crushing other things that people need. Okay. So basically, I summarized that. Now, the analysis here, and we don't have very much further to go. The bubble concept really just gets at the issue of the separation of powers and the issue of definition. As stated at the outset, the central issue confronting us, whenever a judge says that, you got to pay really close attention, laser in, go right in there, is whether the Clean Air Act is sufficiently broad to allow it to apply the bubble concept to the non-attainment area program, non-attainment program. Our decision we observed early observed is controlled. Here she's repeating herself. She's saying, look, I'm just applying precedent. I'm controlled. This is not me controlling it. I'm controlled by what our court said already. And then this is one decision, and here's the other decision. I'm scrolling down here, and you're probably thinking, wow, I'm really glad you're scrolling down. EPA argues, we're on the last page here. Well, last couple pages. EPA argues Well, hold up. Go back up here. These decisions, particularly the Alabama Power Panel's reconciliation of its holding with ASARCO, establish as the law of this circuit, that is, the law of judicial precedent, a bright line test. So, in applying that test to the non attainment provisions of the Act, we must, listen to how she says it, we must conclude, meaning it's out of my hands. I'm forced, I must conclude that the bubble concept may not be employed in that scheme. The non attainment program's raison d'etre, the reason for its existence, is to ameliorate the air's quality in non-attainment areas sufficiently to achieve expeditious compliance with these national air quality standards. That word ameliorate, it means these regulations have to have more teeth if they're going to fix the problem air in these non-attainment areas, the bad areas. And this purpose comfortably places Part D on the improving side of the line, meaning the interpretation of these regulations, which would give them more teeth and really grab a hold of these industries and these companies that would rather not have such stringent standards on new construction in non-attainment areas. EPA argues that we have misperceived the purpose and nature of a non-attainment program. And the agency asserts that a fundamental purpose of the non-attainment scheme is to afford the states flexibility. That will come up in the Supreme Court argument when we cover that next time. The bubble concept, EPA argues, that's the Republican interpretation of this. The bubble concept, EPA argues, would further the statutory purpose by leaving the states with considerable authority to define source as they believe best advised. In other words, giving industry more flexibility in states that are pro-business. They might adopt the bubble concept, or if it's necessary for timely attainment, more stringent standard. Regardless of the method chosen, EPA maintains the states remain under an obligation to submit and comply with a revised SIP that assures improved air quality. Fulfillment of the other prime purposes of the non-attainment program, timely compliance with the national air quality standards, and a reasonable further progress toward the goal, EPA asserts, is thereby assured. In other words, we're giving more flexibility to meet these standards over time. We're giving them more time and more flexibility. Thus, EPA concludes the application of the bubble concept to the non-attainment scheme fits within the purpose. As we recently pointed out, Ruth Bader Ginsburg says, the legal significance of a word or phrase must be gleaned from the context in which it's used. In our precedent, the context purpose clearly means goal or objective. The goal of the non-attainment program is undoubtedly to improve air quality in regions lagging. Offering flexibility to the states may be a method of attaining that objective, but is not an independent goal of the non-attainment scheme. We further note that the permit and moratorium provisions of Part D are wholly federal requirements imposed on the states. The states do not retain flexibility to submit SIPs, which provide for timely attainment of the national air quality standards, but which do not contain a permit program applicable to the new or modified sources, allowing states large leeway to define the sources to which the federal requirements applies is not easily reconciled with the statutory design. Now, what about that? What she's saying there is that although Congress never defined this keyword source, and so EPA took as its own authority to define that, and EPA is in the executive branch and dictated by the president and under a political mandate from elections, Democrats are going to interpret it one way, Republicans are going to interpret it another way. Here, before Chevron deference, Ruth Bader Ginsburg is saying that's not the way it's supposed to be. You're supposed to look at precedent and do the best you can as a judge to figure out what the word should mean so that you can judge which regulations, when they conflict between Democrat and Republican, are the better regulations. She's saying, I prefer the Democrat definition, but she doesn't say because I'm a Democrat. She says it's because of precedent and because it fits with the purpose of the statute. In other words, her definition, the Democrat definition, is more easily reconciled with the statutory design, the purpose, the design of the program that EPA carries out. And the Republican change of definition of the word source is not easily reconciled with that statutory design. The Republicans would prefer a different definition that, so turns out, is easier on businesses and business-friendly states, but still fits within design according to them. But the Democrats think, well, but you're going to pollute more, and the EPA is supposed to prevent that. So who's right? EPA explained, and we're already at the conclusion, so we're almost done. EPA explained that it deleted the reconstruction rule from the non-attainment program regulations because upon the agency's adoption of the plant-wide definition of source, the rule would do scant service. The bubble concept, pursuant to our decision today, may not be employed in non-attainment program regulations. Okay, let me translate this. The Republican EPA under Gorsuch, who is under Reagan, that's Neil Gorsuch's mother, Neil, who's on the Supreme Court now, explained it deleted the Reconstruction rule, the Democrat rule, from the non-attainment program regulations because upon the agency's adoption of this plant-wide definition of source, which they think is a better definition of the word source, the rule would do scant service. And she's saying, well, the bubble concept, this plant-wide definition of source, may not be employed in the non-attainment program regulations. So therefore, EPA's incidental deletion of the Reconstruction rule must be vacated. Okay, so the Republicans lose at the District Court of Appeals under Ruth Bader Ginsburg. Anne Gorsuch loses, Reagan loses. Reagan later goes on to win. And Gorsuch, well, she eventually resigned. I don't know if she was still EPA administrator. I think this took a lot out of her. The prior court's adjudication is what we're using here. We vacate the Republicans' redefinition of the word source. Now, this gets overturned at the Supreme Court in 1984, and that's where you get the famous Chevron USA Incorporated versus Natural Resource Defense Council. And I'm going to go ahead and pull that up right now. I'm going to go back to Google Scholar, and I'm going to search Chevron USA Inc. versus Natural Resource Defense. And I'm looking for something in 1984. Here it is, 467. The U.S. reports starting at page 837, 1984, Chevron USA Inc. versus Natural Resource Defense Council, 1984. Here it is, Justice Stevens. We're going to get to that next time. Now, that's going to only be the second step out of 3 steps. And I'm doing it the fast way. I'm doing this the fast way, I think, because there's a lot of other stuff that could be said. We could talk about our deference. We could talk about deference, period. But I want to restrict it to the primary sources at issue here. Chevron and Loper Bright will be the third part. Loper Bright overturns Chevron. It reverses Chevron, is another way to say it. Okay. Um, and it's all Republicans in Loper Bright versus all Democrats. The Democrats are defending this. The Republicans are saying this was a big mistake. Now, why is this interesting? Because the Republicans in the past year, 2024, are saying when the Republicans won here in 1984, when Ronald Reagan won, Anne Gorsuch won. She ended up winning her agency. The way that happened turned out to be a mistake, and we have to correct that. So it's the interpretation of Loper Bright is that Republicans, including a Gorsuch, that mistake has to be corrected by another Gorsuch. And we have to think about this because going forward, there's going to be new regulations. And what's the role of the court in reviewing these regulations? What's the role of Congress, the proper role of Congress in setting up a regulatory scheme that's permissible? Is your head spinning yet? Well, it's important to talk about. And it's 30 December 2024. So we did it. We broached Chevron deference. Aren't you proud of yourself for making it this far? Now more than ever, it's important to support the Republican Professor podcast. Send a donation. Put your hand in your pocket, dig deep, Venmo at the Republican Professor. Your donation is much supported. It's all worthwhile. It keeps us going. Thank you. Looking forward to seeing you again next time. Take care.